Chris, this is Kelly. I'm having some issues with my camera, but I'll keep trying to turn it on.
Okay, thank you, Kelly, and welcome. Thank you for stepping in. Appreciate it. Good morning, everybody. Welcome to the January 24th, 2025 California Board of Behavioral Sciences Policy and Advocacy Committee meeting. My name is Chris Jones. I'm chairperson of the committee. Before we convene, I would like to remind everyone present that the board is a consumer protection agency charged with administering and enforcing the board's laws. Where protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. Committee members will be participating remotely from private, non-public sites. The public may participate remotely or in person at DCA headquarters at 1625 North Market Boulevard, Suite S102. I will announce when we are accepting public comment on the various issues, and the meeting moderator will open the lines as appropriate. Each commentator will have 2 minutes to comment. Moderator, would you please provide the audience with instructions on how they may participate during the meeting at the appropriate times?
Yes, this is the moderator. When we open up for public comment, you may click the raise hand icon next to your name. Additionally, you may also use the question and answer feature that will show up when the public comment is called. For audio only participants, you can raise your hand by pressing *3 on your device. You'll be given 2 minutes to speak with a 30-second warning, and then at the end of your time, you will be muted and we will move on to the next person requesting public comment.
Thank you, moderator. Our first item is call to order. I would like to ask Christina to call the roll to establish a quorum.
Good morning.
Good morning.
Chris Jones.
Present.
Abigail Ortega.
Present.
Kelly Ronasinghe.
Present.
And for the record, John Sovek and Wendy Strack are absent. We have a quorum.
Thank you, Christina. Board staff, would you please introduce yourselves?
Good morning, Steve Sodergren, Executive Officer, Board of Behavioral Sciences.
Roseanne Helms, Legislative Manager with the Board.
Christy Shields, Legal Counsel for the Board, substituting in temporarily for Sabina Knight.
Marlon McManus, Assistant Executive Officer for the Board.
Christy Berger, Regulatory Manager for the Board.
Sarita Risso, Special Projects and Research Analyst for the Board.
Is that everybody?
Yes.
Perfect. Thank you. Now is the time for the public to introduce themselves if they'd like to. This is voluntary. Is there anyone in the audience that would like to introduce themselves?
We have one person.
Oh, it's on. Yes. Good morning. Happy New Year. Shanti Ezrin, California Association of Marriage and Family Therapists.
Welcome.
That's all for in the audience.
All right. And anyone from our remote participants?
All right, this is the moderator. Members of the public on WebEx, if you would like to introduce yourself, you can either raise your hand or click that Q&A icon. It looks like I have Kathy Atkins. Kathy, I'm going to unmute your microphone.
Good morning, everyone. This is Kathy Atkins from the California Association of Marriage and Family Therapists. Thanks for having me.
All right, this is the moderator. Next, I have Ben Caldwell. And Ben, I'm going to request to unmute your microphone.
Everyone, Ben Caldwell, licensed MFT. I'm adjunct faculty for Cal State University Northridge, and I run High Pass Education, which does continuing ed and exam prep. Happy New Year. It's good to be with you.
All right, this is the moderator. Next, I have Dr. Sabrina D. Morris. And Dr. Morris, I'll request to unmute your microphone now.
Sabrina Morris from California Association for Licensed Professional Clinical Counselors. I am the president of the board of directors, and I'm also faculty at Antioch University, Los Angeles. I'm a licensed LPCC.
This is the moderator. Next, I have Sarah Carrasco. And Sarah, I'll request to unmute your microphone now.
Good morning. This is Sarah Carrasco with William Jessup University from our graduate program, and I am the licensing and compliance specialist. Thank you for having me.
All right, and this is a moderator. I have Elise Springer, and Elise, I'll go ahead and request to unmute your microphone now.
I'm a marriage and family therapist and a California chapter of Postpartum Support International. Thank you.
All right, this is the moderator. I believe that was everyone who wished to introduce themselves.
All right, thank you, moderator, and welcome everyone. I appreciate you introducing yourselves. The first agenda item is discussion and possible approval of the October 11, 2024 committee meeting minutes. Does any member wish to remove or edit any items from the consent calendar? No, then do we have a motion to approve the consent calendar? All right, I'll motion to approve the consent calendar. Do I have a second?
Second.
Are there any comments from the public? In the public that are in the audience?
No.
All right, any comments from our remote participants?
This is the moderator, and the public comment is open for agenda item 3. If you would like to make a comment on agenda item 3, you can either raise your hand or use that Q&A box down at the bottom right-hand corner of your WebEx screen. Audio-only participants can raise their hand by pressing *3 on their device. All right, and seeing no requests for public comment, would you like me to close that Q&A feature?
Yes, thank you, moderator. Christina, would you please take the vote?
Chris Jones,
Yes.
Abigail Ortega,
Yes.
Kelly Ranasinghe,
Yes.
motion carries.
Thank you, Christina. Next on the agenda is the discussion and possible recommendations regarding approval of proposed regulatory amendments and preparation of documents to initiate a rulemaking to accept the Association of Marriage and Family Therapy Regulatory Board's Marital and Family Therapy National Examination as the clinical examination for California licensure. Roseanne, would you please provide us with overview?
Yes, thank you, Chris. So the board has been moving through the steps that would be required to accept the AMFTRB national exam as the clinical exam for LMFT licensure. And there's a number of things that need to happen in order for that exam to be accepted. So basically a quick overview. Right now, the board administers the LMFT clinical exam. The board does not utilize the national exam. The board is the only state that doesn't utilize the national exam currently. The board has already adopted a national clinical exam for LPCCs and LCSWs, and the board is working toward exploring the feasibility of adopting the AMFTRB national exam as the clinical exam. At recent meetings, the board has identified several steps that would be needed to do this and has directed staff to pursue those steps. So some of the things that staff is working on, that the board has asked staff to work on, is we are collaborating with AMF-TRB on addressing exam content and measurement scope concerns. We're collaborating with AMF-TRB on addressing accessibility for testing candidates to ensure that if and when the switch happens, that candidates are not adversely affected by the transition to the national exam. We are working with the DCA's Office of Information Services to ensure an automated system would be in place for transferring national exam eligibilities and test scores. And then finally, we would need to, and we are in the process of pursuing statutory and also regulatory amendments necessary to accept the exam. And so the regulatory amendments are what we're going to talk about today. The board is already in the process of pursuing statutory amendments. The board approved language for the statutory amendments at its last meeting, and they are probably going to go in the board's sunset bill this year. We're waiting for 100% confirmation on that. But the statutory amendments really just set the table for allowing the board even the possibility of adopting a national exam. There's certain things that the law needs to say that allow that in order for that to happen. So we're pursuing that. The legislative process this year would start in this January or February. A bill would be introduced very soon. The bill would likely be signed at the end of September, early October, and then the changes needed in law would go into effect January 1st if everything went smoothly as we're planning this year. And those statutory amendments are currently shown in attachment B. However, the statutory amendments would not be the trigger to adopt the AMF-TRB national exam. That would need to be done via regulatory amendments. Then the regulatory amendments would officially and specifically name the AMF-TRB national exam as the clinical exam the board accepts toward LMFT licensure. So that would be the official trigger there. So the regulatory process is quite lengthy, just like the process to amend statute. Proposed regulations involve an initial review process with the director of DCA, the DCA Budget Office, the California Business, Consumer Services and Housing Agency. And then at that point, they can be officially filed with the Office of Administrative Law to be considered as a regulatory amendment. And so we're looking to sort of, while the statute is running this year, to sort of get a jump start on having those regulations written, so that if everything goes smoothly with the statute process and the work that the board staff is doing with AMF-TRB behind the scenes, that the board would be able to more quickly sort of pull the trigger on pursuing the regulatory amendments. There's still going to be a review process and time involved, but if we have the amendments ready to go, then it'll be able to be a little bit quicker at least. So what we're recommending today is we have the proposed regulatory amendments in attachment A, and we're recommending that the board approve in concept the proposal shown in attachment A. And then the plan would be that once staff has finished collaborating with AMF-TRB and OIS to meet the criteria that the board had identified at its past board meeting in steps 1 through 3 in the memo here, then the regulatory proposal would be brought back to the board one final time for final consideration and authorization to begin the rulemaking process. So today is sort of the approving concept. We'll get all of the paperwork and the things that are required ready to go, which is quite extensive. And then we would bring it back one more time, likely this fall, report on how things have gone with AMF-TRB, report on how things have gone with the statute, and then the board could decide whether or not to basically say go forward with the regulations, which are is the final thing needed. So I think that I'm going to open it up for discussion right now. We have a very specific motion, depending on whether the board has or the committee has any proposed amendments to the language. But basically, the motion today would be to approve in concept and then bring back for final consideration a few months down the road once some more things are done. But at this point, I'll open it up for discussion.
Any comments from our committee members? No. I thought the language in Amendment A was fine. Roseanne, I didn't see any issues with it. I appreciate the work that you put into it. I know that this has been a labor of love. No other comments? Would anyone like to make a motion? All right, I'll make a motion. Motion A, which is no changes are requested by the committee. Recommend to the board approval of the proposed regulatory text in attachment A in concept, and recommend that the board consider all of the following actions. Do you want me to read them? Do I need to do that? Okay. 1, approve the proposed regulatory text in attachment A in concept. Direct staff to draft the initial rulemaking documents in preparation for possible submission to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for initial review and approval. And then 2, once the criteria in steps 1 through 3 under the section implementation steps set forth in the meeting materials have been met, bring the proposal in attachment A back to the board for final consideration and authorization to submit the rulemaking package to the director and agency for review and approval. Do I have a second?
Chair, I will second.
All right. Thank you, Kelly. Are there any comments from our participants in the meeting room?
Yes, there are.
Okay, hello, good morning again. Shanti Ezrin with CAMPT. CAMPT continues to be in really strong support of all the necessary amendments to accept the AMFT-RB national exam. A couple other things I want to share too. We continue to receive really strong support from our board and from our members as this transition to the national exam will help with license portability, continuity of care for patients, supporting the workforce on a national level, and of course, making the national exam requirements consistent across all licensure types. And I also want to take a second to thank staff and the board for all of the work with AMFT-RB behind the scenes to work on those implementation steps that were outlined in the materials. Namely accessibility of the exam and also addressing any disparities in exam rates. Please continue to let CAMPT know how we can assist in those efforts, and understanding that this item today is to approve the proposed regulatory language in concept. We do believe that this will help streamline the process as statutory amendments are also being run this year as legislation and have no concerns with the text as proposed. Thank you.
Thank you. Any comments from our remote participants?
This is the moderator for members of the public on WebEx. If you would like to make a comment on this item, you can click the Q&A icon or use the raise hand icon. And it looks like we do have a couple requests. First, I have Ben Caldwell. And Ben, you'll be given 2 minutes to speak with a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Good morning. Thank you. Ben Caldwell, MFT. I'd second what Shanti had to say in thanking the board and staff for the good, diligent work you've done so far. I know it's quite an extensive process to get this done. So thank you, and certainly in strong support of the changes that are proposed here. A couple of questions, if they can be addressed. One is, what would the current timeline be for adoption of the national MFT exam if all goes well, if all this goes kind of according to plan? And then 2, what would the process be for public participation to the extent possible in discussion of those measurement and scope concerns with the AMFT-RB exam that Roseanne had noted? Certainly, as stakeholders, we want to be as active in that discussion as possible. Thank you.
I can speak to that. So in terms of the timeline, we're at least a couple of years out. The legislative process would have to run first this year. We can't move any regulations until the statute is actually signed by the governor. So that would happen in late September, early October. From there, the process, although usually the reg process is about anywhere for like about a year. Sometimes it can be a little bit less or up to a year and a half. We're trying to cut as much time we can off of that by already having the proposal ready to go. But it's still going to be a process that goes through the various agencies that it has to go through. So that's, and then we would have to just talk about a date when the exam would actually implement, when the switch would take place. So we're looking at least probably a couple of years. In terms of the process for the public participation, when the legislation is signed, we would have an agenda item at a board meeting where we would talk about the regulations and bring them forth for final approval. We would also report back to the board on the work that the board has done with AMFTRB and OIS, and the public would have a chance to participate in that particular discussion. There would also be, with the regulations, there's always public comment and participation, regulation hearings or public comment periods for that as well.
Thank you.
Thank you, Ben.
This is the moderator. Next, I have Kathy Atkins, and Kathy, you'll be given 2 minutes to speak with a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Good morning, everyone. Kathy Atkins with CAMPT. In addition to just a general ditto to what Shanti and Ben brought up, both comments and questions, I just wanted to reiterate and underscore an appreciation to the BBS staff and Roseanne for their work on this, and also the foresight of doing the work in advance. I don't know that would have occurred to me. So I just really appreciate that forward thinking. I think it will really help with this process, as well as outline if there's areas that need to be improved. I think doing it this way really just improves the whole process. So just a huge applause to the staff. So thank you.
Thank you, Kathy.
All right, this is the moderator. Appears that was all our requests on WebEx.
Excellent. Thank you, moderator. Are we ready for a vote? Yes. Christina, would you take the vote?
Yes. Chris Jones,
Yes.
Abigail Ortega.
Yes.
I'm sorry, I didn't hear you, Abigail.
Yes.
Thank you. Kelly Ranasinghe.
Yes.
Motion carries.
Thank you, Christina. Next on the agenda is the discussion and possible recommendations regarding statutory amendments to the board's retired license requirements. Roseanne, would you please provide us with the overview?
Yes, thank you, Chris. So the retired license status was established first back in 2011. At that time, it was established because a licensee who wished to retire at that time only had two options. They could place their license in inactive status and continue to pay a biennial renewal fee of half the regular fee, or they can allow their license to become delinquent and it would be automatically canceled after 3 years. So at that point, the retired license became an option, and a licensee who now chooses to retire their license has to do a few things to be eligible. They have to have a license that's either current and active or in an inactive status, so it can't be delinquent or expired. It must also not be suspended, revoked, or subject to any disciplinary action. They must pay a one-time application fee of $40. And once retired, the license no longer needs to be renewed. You cannot practice, however, on a retired license. So it's just sort of a ceremonial way to kind of retire the license and sort of memorialize it. In terms of what happens if somebody retires their license and then changes their mind, a retired license can only be restored to active status for up to 3 years. If somebody wants to restore their license, they need to submit an application to restore it to active status, pay a renewal fee, do fingerprints, and complete up to 36 hours of CE, depending on how long it's been retired. If the license has been retired, though, for more than 3 years, they cannot restore it. The applicant must apply for a new license, paying all applicable fees, meet all current licensing requirements, meaning if there's any new coursework that we've required since they got their degree, they would need to complete that, pass both exams required for licensure, and then submit fingerprints. A lot of people have utilized the retired license status. We currently have about 2,900 retired licensees. And occasionally somebody does change their mind and wants to apply to restore their retired license to active status. This happened we have about 60 of those since 2014. And you can see the data there. So not a ton of them, but changing one's mind does happen. So we've been kind of knowing that our license population is aging. We've been kind of looking at our retired license statute, comparing it to some of the other boards' retired license statutes, and seeing if there's any way we can streamline that process to make it a little bit less cumbersome while still maintaining public protection. So we started looking in previous committees. We reported on some changes that the Board of Registered Nursing had done to revamp their retired license laws. We reviewed some other boards' laws, and those can be seen in Attachment B. Originally, when we had presented this proposal, we're trying to focus on eliminating the requirement that a retired license who wishes to restore their license to active status after being retired for 3 or more years must apply for a brand new license. We had thought about proposing a longer period, such as up to 7 years. However, when we took that proposal and did a little bit more searching at other boards and consulted with legal, we realized that particular thought might have some unintended consequences of allowing reinstatements beyond 3 years. Our law doesn't allow for any type of reinstatement beyond 3 years, so we would have to change that law as well in order to do this. We also had concerns about the process of having different reinstatement requirements after differing number of years. For example, we were discussing possibly requiring the law and ethics exam after 3 years, but the clinical exam after 7. And when we really looked at it on paper, we kind of concluded that it created a more confusing process. And it created a discrepancy in the requirements between the LEP license and the board's other license types because they don't have a separate law and ethics exam and clinical exam. So that we couldn't really make things equal in terms of when and the exam had to be taken. For these reasons, we kind of decided to shift directions and focus on some other clarifications we could make to the retired license status. So those are shown, the proposal as it stands today is shown in Attachment A, and it does a few different things. And really the main thing that it's sort of correcting for people, which is something that we hear a lot of, is that instead of when somebody goes to retire their license, instead of right now, the license that they want to retire has to either be current and active or it has to be inactive. And we get a lot of people requesting to retire their license and they've already let it expire. So the proposal, as long as the license is expired within the past 3 years, so it hasn't been expired for many, many years, only up to 3 years, we would permit a license that has been expired for up to 3 years to be retired. And this would remove the barrier of requiring somebody who had just let their license expire. Right now, if they wanted to retire it, they would have to pay to either reactivate it to active or inactive status, simply then to pay another $40 to turn around and retire it. So it would remove that sort of administrative burden step, but only for people that hadn't been expired for too long, no more than 3 years. So that's the main part of this proposal that we think will be helpful to people based on the what we hear as staff in the office when somebody's interested in retiring their license. We did a few other things in the proposal as well. We clarified the meaning of what subject to disciplinary action is when we say your license can't be subject to disciplinary action to retire it. There's no definition of that term. We specified more clearly what information needs to be provided in the application to retire a license and also to reinstate a retired license. We're specifying the professional title that a retired license is permitted to use. We're restricting a retired license to reactivating their license one time only. We're correcting a reference to fingerprint submission requirements. And then we're specifying how old the continuing education that's required to restore a retired license needs to be. And then we're clarifying that a license that's been retired 3 or more years can't be restored and that a new license must be reapplied for. It can't be just restored or reinstated. So the proposal, like I said, is shown in attachment A. Chart 1 sort of includes a summary of what it takes to restore a retired license. And with that, I'll open it up for discussion.
Any comments from our committee members?
Chair, I don't have a comment, but I'm going to be leaving the room for approximately 1 minute to 2 minutes, and I'll be right back.
Should we pause comments until Kelly returns?
I would.
Yeah.
This is Christy Shields, legal counsel for the board. One other issue that this proposal is intended to address is the need for regulations. So we've drafted the proposed amendments with the idea that the statutory changes would be self-executing. And so please review the proposal with that in mind, because we're trying to avoid having to do a regulation to further implement the retired license status changes were discussed today. So that's why there's so much detail here, which is not typical for statutory amendments.
Thank you.
Thanks. So if there's a quick pause, I can jump out of the room and then I'll be right back.
Oh, yeah. Okay. Thanks, Kelly.
Appreciate it.
Okay, let's just take it. How about just 5-minute break and we'll come back.
Yeah, let's do that. Thank you. Good suggestion, Steve.
Sure. Chris, and then Kelly, if you're having issues with the camera, can you just restate that, please, for us?
Yes, for the record, I am having issues with my camera. It is not operational. My location is 950 West Main Street, El Centro, California, where I'm present on the 2nd floor. I have tried several times to get my camera to work, but it is not working.
Thank you. I appreciate that. Thank you, Kelly. And Chris, we're back.
Apologize. I made the mistake of stepping outside of my office, and I work in a busy school. So I got bombarded. Are we ready to continue?
We're good to go.
Perfect. Okay, were there comments or discussion from our board members regarding Roseanne's presentation? Abigail?
It says that the CEUs, right, they have to complete all their CEUs and their law and ethics. Do we have like any concerns that like the requirements might be too burdensome for some of the individuals that retired but then changed their mind and have been out of practice for so long? Just wondering, like, do we have any insight into like why someone would retire and then come back, and would this like add to any burden?
Christy Shields, legal counsel for the board. So this is a pretty universal requirement for people that are coming back into practice who haven't been in practice. And it's assurance that they have updated their competency and education since they've been out of practice for a period of time. And it's just a way that the boards in this department assure the public that they have currency of knowledge before they are reinstated. And we have not had, is to my knowledge, in my 25 years here, anyone complain about that requirement?
Additionally, I'd add that the 36 hours that we're requiring is the same for a 2-year renewal. So any licensee that's been licensed still has to complete the 36 hours. We just wanted to specify an age consistent with somebody who's renewing so that it's not really old CE.
So if I'm understanding correctly, then, and that they would need to, for 3 years, for less than 3 years, they would just need to do their 36 hours and pay the fee, almost like they were just renewing their license, versus if they wait for more than 3 years, and they would need to start the process over.
Yes, that's correct.
Yeah. No, that makes sense to me. Does that answer your question, Abigail? Perfect. Kelly, any comments?
No comments from me, Chair.
All right. Then do we have a motion?
Okay, the motion, we have public comment, but let me say the motion first. The motion would be to direct staff to make any discussed changes and any non-substantive changes and bring to the board for a consideration as a legislative proposal.
I so move. Do we have a second?
Second.
Perfect. Do we have any comments from our participant in the audience?
Yeah, we do.
Participant singular.
Yeah. Shanti.
Hello, my name is Shanti Ezrin with CAMP. Thank you to staff for your work on this. And Roseanne, I think you said it best when you said that this work is to streamline the process while also maintaining public protection. And after taking a look at the proposed language, we see that these clarifications to be appropriate as proposed, and especially that first piece that you were talking through, allowing expired licenses within 3 years to be retired, should be a helpful piece for certain licenses. Thank you.
Chris, your mic.
Sorry about that. I said thank you, Shanti. And do we have any proposals from our any comments from our remote participants?
This is the moderator, and we have opened up public comment for members of the public on WebEx. If you would like to make a comment on this item, you can click the raise hand icon or the Q&A icon down at the bottom right-hand corner of your WebEx screen. Audio-only participants can raise their hand by pressing *3 on their device. All right, and it appears there are no requests for public comment on this item.
All right. Thank you, moderator. Christina, would you take a vote?
Chris Jones,
Yes.
Abigail Ortega,
Yes.
Kelly Ranasinghe,
Yes.
motion carries.
Thank you. All right, our next agenda item is the discussion of research regarding the practice of pastoral counseling. Sarita, would you provide us with the overview?
Yes, thank you. So the board's practice acts require a valid and active license or registration to provide services within the scope of marriage and family therapy, clinical social work, professional clinical counseling, and educational psychology. Currently, the law exempts individuals performing counseling services as part of their pastoral or professional duties, such as priests, rabbis, and ministers of the gospel of any religious denomination. The board's exemption statutes are currently stated in the Business and Professions Code sections for LMFTs, LPCCs, and LCSWs outlined below in the memo. While there are benefits to pastoral counseling for clients that are seeking guidance in areas where there may be limited services offered by licensed mental health professionals, there's also concerns when the services performed in pastoral counseling by individuals who are unlicensed and may have limited training overlap with the services performed by licensed mental health professionals. The board has occasionally received consumer complaints where services are performed by an unlicensed individual who appears to be working in their ministerial or pastoral capacity, but incorporating psychotherapeutic methods into their counseling. And is noted in such complaints, the individual is often providing counseling services independently outside of the client's church or other religious entity, and the counselor may be charging a fee for their own private practice, such as an LLC. In some cases, the board is unable to take any action due to the language in the current exemption laws. The topic of pastoral counseling was last discussed at the former licensing committee meeting in June of 2023. The intent of the discussion was to propose clarifying the exemption language in the board's practice acts for individuals performing duties in a religious or faith-based profession. I do want to note that the intent is not to regulate individuals performing ministerial or pastoral duties. We just wish to possibly make the exemption language outlined in our statutes more clear. So at that licensing committee meeting, staff presented examples of exemption laws in the states of Texas, Florida, and Arizona. So for the state of Texas, the Texas State Board of Examiners of Marriage and Family Therapists, the administrative code states that they do provide a definition for a recognized religious practitioner as a rabbi, clergyman, or person of a similar status who is a member in good standing of and accountable to a legally recognized denomination or legally recognizable religious denomination or legally recognizable religious organization, and then and other individuals that are participating with them in pastoral counseling. That's if that therapy activities are within the scope of performance of regular or specialized ministerial duties and are performed under the auspices of sponsorship of an established or legally recognized church, denomination, or sect. And also, the administrative code provides that the individual providing the service remains accountable to the established authority of that church, denomination, sect, or integrated auxiliary, and the person does not use the title or hold himself or herself as a licensed marriage and family therapist. This is the administrative code that pertains to a licensed mental health marriage and family therapists, just to note. For the state of Florida, that was another exemption language that was provided as example. The Florida statutes pertaining to clinical counseling and psychotherapy services states that no provision of their chapter or statute should be construed to limit the performance of activities of a rabbi, priest, minister, or member of the clergy of any religious denomination or sect, or use the terms Christian counselor or Christian Science counselor. They also do note compensation if there's no compensation received, and if they're performing within, their regular or specialized ministerial duties. And so for the state of Arizona, the third state that was also presented at that previous meeting, per their statutes, exemptions to licensure statute that exempts a rabbi, priest, minister, or member of the clergy of any religious denomination or sect if the activities and services that person performs are within the scope of the performance of their regular or specialized ministerial duties of an established or legally recognizable church, denomination, or sect, and the person performing the services remains accountable to the established authority of the church, denomination, or sect. Since that time, board staff has since collaborated with subject matter experts to conduct further research on pastoral counseling, in addition to clarifying the differences in practice methods used in pastoral counseling and mental health professions. There's material that's outlined in the memo of some of the publications and dissertations that were retrieved in our research process. And notable information that was found on those reference publications, there is a definition of a pastoral counselor. This is per the definition that was provided back in 2005 by the American Association of Pastoral Counselors, that defines a pastoral counselor as a clergy member has received graduate training in both religion and behavioral science for a clinical practice that integrates psychological and theological disciplines to increase meaning and well-being. To practice independently or in a clinical setting, pastoral counselors must attain the same state licensure as a secular counselor. And then counselors in the field of pastoral counseling do not need to hold a license if they were, quote, providing faith-based counseling. And while there are benefits to therapy and pastoral counseling, only therapy is designed to treat mental health conditions with evidence-based approaches. So we did look into other states' exemption laws, and we just looked into it considering the diverse religious and cultural influences in those states. So we did pull additional exemption statutes for the states of Georgia, North Carolina, Louisiana, New Mexico, Virginia, and Vermont. So I'm not going to read each one verbatim, just kind of highlight the main points in each statute. So for the state of Georgia, their statute exempts active members of clergy, but quote, only when the practice of their specialty is in the course of their service as clergy. Also exempts members of religious ministries responsible to their established ecclesial authority who possess a master's degree or its equivalent in theological studies, and also exempts persons engaged in a practice of a specialty in accordance with biblical doctrine in public or nonprofit agencies or entities or in a private practice. And they do note that, no such persons should hold themselves out as a licensed professional, especially in license to practice in the areas of professional counseling, social work, and marriage and family therapy. For the state of North Carolina, it's noted in in the state's general statute of their intent to not regulate members of other regulated professions where counseling is a normal course of the practice of their profession. So their statute doesn't apply to, quote, any ordained minister or other member of the clergy while acting in a ministerial capacity who does not charge a fee for the service, or any person invited by a religious organization to conduct, lead, or provide counseling to its members when the service is not performed for more than 30 days a year. For the state of Louisiana, per the state's practice acts, rabbis, priests, Christian Science practitioners, or ministers of the gospel of any religious denomination are exempted from the licensing requirements in the state, provided, quote, that they are practicing within the employment of their church or religious affiliated institution, and they do not represent themselves as licensed professional counselors or mental health counselors unless they have been licensed under the provisions of their practice acts. In the state of New Mexico, duly ordained, commissioned, or licensed ministers of the church providing pastoral services on behalf of the church are, quote, specifically exempt from New Mexico's Counseling and Therapy Practice Act. For the states of Virginia and Vermont, their statutes are almost the same. But for the state of Virginia, their exemption from licensure requirements for professional counseling doesn't apply to, quote, the activities, which include marriage and family therapy, counseling, or substance abuse treatment of rabbis, priests, ministers, or clergymen of any religious denomination or sect when such activities are within the scope of the practice of their regular or specialized ministerial duties, and no separate charge is made, or when such services are performed, whether with or without charge, or under the auspices of sponsorship, individually or in conjunction with others, of an established or legally recognizable church, denomination, or sect, and the person rendering service remains accountable to its established authority. And so with that in mind, we just would recommend conducting an open discussion regarding the practice of pastoral counseling and whether amendments should be made to the board's statutes.
Thank you, Sarita. That was pretty detailed. We appreciate that. A lot of work went into that research. Do we have any comments or thoughts from our committee members? Quiet today. Abigail.
Or you have to like look for the icon to raise your hand and then unmute yourself. It's more steps. I guess there were some complaints to the board that led to right, this conversation that we're having here and making these amendments. And I'm curious about like how are we gonna like regulate, I guess, or better educate the public about the differences to like avoid confusion and eventually what are how are they how are different states managing all of this? What would happen if we got a complaint again? And so yeah, how is it being enforced, I guess, is the question.
Yeah. Well, once if we did pass, more amendments to the language, we would definitely do education out there with FAQs. It just really helps us to clarify, because that's been the confusion where we get these, and actually a lot of times the complaints we get are from, I won't say a lot of times, but sometimes there are people that have actually gone through and have education in a master's degree in some psychological component, and then they go in and they say they're doing pastoral counseling, and it gets us really concerned that how do we determine what that is. So this definitely helps to define that, and it would help for those that are providing pastoral counseling to identify if they are following the rules or not. It would be education though. And it really helps us in our process just to make sure the consumer is protected and there's not unlicensed practice. And somebody who is maybe doing pastoral counseling is make sure that they're not, unless they have the credentials, not doing any psychosocial therapy at that time. And Roseanne, you probably can do that a little more eloquently.
I think our main concern when we get these enforcement cases, we've had a few cases where we were not able to take action because the law is as written right now, it's pretty vague. However, the complaints that we were unable to take action on showed clear signs of maybe not being done under the guise of a physical church. It was more somebody that had, it looked like they were going out on their own. They were charging. It looked a whole lot like a private practice, things like that. And it's like, where do you draw that line? And by tightening the law a little bit around pastoral or faith-based counseling, could we kind of make it a little bit more clear that this is not intended to be your own private practice where you're doing pastoral counseling. It needs to be part of a religious affiliation or institution. maybe, the discussion can be, should they be getting paid directly by the client if they're doing that? Do we want to pursue some sort of a statutory or regulatory change so that our law is a little bit stronger when we get those cases?
All right. Abigail and then Kelly.
Yeah, and is there anything we can do so that maybe titles like therapist or counselor are not used in fields where they're not licensed? Because I think that's where a lot of the confusion comes in. Even for me, I'm not really clear either.
On the title, I mean, we do have rules for using the title of using the title within our scope of practice. So we have that. I don't think that we can't really restrict the use of pastoral counseling as a title.
Yeah, we can't restrict pastoral counseling. They can't, even right now, they can't call themselves a marriage and family therapist, clinical counselor, but it's more the question of when somebody's doing all of these things and it looks like a private practice, but they're saying, oh, I don't need a license because I'm doing this, I'm a pastor or something like that. Where is that line? I think Christy,
I think that's been kind of the one key point is in these cases when we're looking at them is making that connection between, are you practicing, are the services that you are giving, is that part of your church duty or not? We've had cases where somebody claims to be, doing those as part of their duties for their church, but they're collecting fees and it looks like there's no linkage between the church and them practicing this therapy on the side. So this helps to define that.
Kelly?
That's what we're seeking to do.
Well, I agree with Roxanne and as well as with board member Ortega. I have grave concerns that this area is sort of a salient or an amorphous area where there's a dimension of abuse or manipulation that could occur, particularly since you're dealing with a vulnerable population. There is a dimension of abuse called spiritual abuse, which occurs when faith leaders and clerical staff, of any denomination, take advantage of their position. And I also have distinct grave concerns about this area, particularly if someone is holding themselves out as a pastoral counselor, but they have all the trappings of a licensed counselor. They have a separate office, physically separate from their religious institution. There's no sign that it's part of the religious institution. They're collecting fees. They might have a business. Then it begins to take on the role of really unauthorized practice. Is the Attorney General's as forthright in our concern as we are, Steve?
Really, we haven't really brought this subject up, or has been a subject with the Attorney Generals. It would be in the cases, and I can't really say what conversation we had during the current cases that we've had. That's something to look into. And
this is Christy Shields, legal counsel for the board. So in my experience in working with the board, the problem, well, it's not really a problem. It's a constitutional issue with respect to the California's free exercise clause. That's Article 1, Section 4 of the California Constitution. I think a lot of people think of the freedom of religion portion in the federal Constitution, but the California Constitution's protections are even broader, and they guarantee the right to practice religion without discrimination or no religion at all, really. And so I think that the problem area is knowing where that line is when there's a practice that's faith-based versus someone actually acting in the capacity of a licensee for remuneration. So we're talking about people that are paying money for the service. People that get free counseling, they're exempt from the board's jurisdiction. So frequently, a lot of people will say, I didn't collect a fee, and they'll get out of it that way. But the kind of the area that's the sticky wicket, if you will, is, when it's faith-based counseling versus when they're actually practicing as a marriage and family therapist or any of the other licenses the board regulates. So that's the part that's, I think, stymied a lot of investigations in my experience, is when is it a practice of the, of the religion? When it's the counseling really a faith-based counseling, and when is it becoming looking more like they're practicing as a licensee in one of the various professions regulated by the board? So that's kind of been, I think, in my experience, the problem that the Attorney General's office has raised with some of our cases. And the reason the staff are bringing this to you is seeing if there's a way to tighten up the statutes to make it clearer that maybe when it's faith-based counseling, they're exempt, but when you're representing or holding yourself out to do these services that, like for instance, in the LCSW statute where it talks about hold themselves out to the public by any title or description of services incorporating the words psychosocial or clinical social worker, that sort of language, you could look at maybe amending your other statutes to include that kind of specificity.
Kayla, I'll get to you in 1 second. So yes, I agree that we should probably tighten up the language about what constitutes a therapist or therapeutic practice versus pastoral counseling. The thing that's hard going to be, at least the way that I see it, will be difficult to deal with is when you have people that have gone through training. They've had maybe they went through MFT program or LCSW program, and then for whatever reason didn't get their license, but now are going to do pastoral counseling. You can't turn those skills off, right? So how are we going to determine whether or not they're using therapeutic technique with their counseling clients? I don't I heard Sarita say earlier, we can't regulate them, but is there a way, and this is maybe what we're talking about, to better define what a therapeutic mental health practitioner is versus what pastoral counseling is? And I know that we don't often want to get super specific because then we end up with either pitching us or end up with unintended consequences. So is that our intent here, to make a more of a clear line in the sand about if you're doing A, B, and C, then that falls into the therapeutic mental health professional that needs to be licensed, versus this is what pastoral counseling looks like. But then I wonder, are we defining what pastoral counseling looks like, and do we have authority to do that? Sorry, that was a lot of questions.
This is Christy Shields again. I mean, that's the crux of it. How do we not cross the line into regulating religious freedom and practice? So, I mean, one of the things I did like in the materials was the reference to what's called quote unquote faith-based counseling, because the current statutes just say when performing counseling services. So, I mean, what does that mean? And what kind of counseling are you talking about?
Right.
And the other statutes that talk about being accountable to an established authority. Well, in California, you don't have to have an established authority to practice your religion. So I don't think that's helpful. So I think maybe looking at ways to talk about what they're performing and when they're stepping into the professional role of providing psychotherapeutic services or psychosocial counseling. It's tough. I think there's going to need to be more research probably done to try to see if we can add language that would make it clearer. But I think, like I said, that the concern is crossing over into that constitutionally protected right to practice your faith
Right.
or religion.
Because worst case scenario could be that somebody creates their own religion and uses that as the vehicle to provide counseling services, create some sort of nonprofit where people are making donations and then they don't have to charge for the counseling. And then they're just kind of running free under the auspices of it being a religious freedom. Sorry, that's like catastrophic thinking, but that's kind of where my head goes. Kelly.
Yeah, that actually is what I was about to say. I completely agree with Board Member Jones. You know, one thought might be to have a determinative statute, but I worry that then we begin to get into the weeds. You know, a determinative factorial statute would be something like, in determining the legitimacy of this counseling versus, you know, unauthorized practice of law, the court shall consider blah 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 blah, and you have a list of factors like, you know, the separateness between the counselor and their named religious institution and stuff like that. But you know that I wish there was some appellate case law on this that would help us look at the interpretation of this statute. Yeah, it's a really difficult question.
Any other thoughts from my committee members? So would the action be, Roseanne, that we would be directing staff to continue doing research and draft up, you know, possible solutions to this so that we could make things more clear?
Yes, that's kind of the ultimate, what we would like to see happen is that, you know, we make those definitions of faith-based counseling in our law a little bit clearer by, you know, possibly saying, you know, what unlicensed faith-based counseling looks like, whether that's not charging a fee or being connected with a direct religious institution, which might be a little bit tricky. It's really dancing around that second thing. So yes, I think that there's some more research that's needed to go forward, and maybe we can, you know, take a look at that and present a couple of options to talk through a little bit more. We're thinking this is going to be a process. It's not going to be a slam dunk right away because it's a really fine line.
Sure. So then if we direct staff, that doesn't require a vote, correct?
I don't think so. Christy says probably no.
I don't think if you have any specific action you want them to do, you need a motion for this item. I think they've heard your concerns and they'll continue to work this issue and bring it back to committee at a future meeting.
Okay, perfect. Then I'd like to hear from the public. If we don't need to, we will direct, but I want to hear from the public if they have comments on this issue. So we'll start with our participant in the audience.
Shanti. Well, that's me, Shanti Ezrin with CAMT. First of all, I just want to thank Sarita for your copious research on this item. You know, understanding some of the concerns and consumer complaints as you put in the materials and then the conversation here, you know, we're generally in support of clarifying exemption language for those individuals to ensure adequate consumer protection. The examples that you provided from other states, I think, are a good starting point, and there seem to be maybe some examples that we can draw from there that can offer some appropriate clarification to our law, while it's still not crossing into regulating religious freedom. So all that being said, understanding that this is just a initial discussion, and you'll kind of go back and take a look at some possible solutions and bring it forward. We're looking forward to reviewing that proposed language and just kind of going from there. Thank you.
Thank you, Sean. Do we have any comments from our remote participants?
This is the moderator, and for our members of the public on WebEx, you may make a public comment on this item by clicking the raise hand icon or using the Q&A feature down at the bottom right-hand corner. Audio-only participants can raise their hand by pressing *3 on their device. All right, and this is a moderator. It appears there are no requests for public comment.
Thank you, moderator. All right. So yeah, I believe our direction is to keep doing your research, Roseanne and Sarita. Thank you for the research. That was a lot of work. So this is a really important topic. So we appreciate you guys. Okay, next on the agenda is the update on board sponsored and board monitored legislation. Roseanne, would you provide us with the overview?
Yes, thanks, Chris. So the legislative session is just getting underway this month. So the legislature is in the process of introducing bills, and they have till about mid to end of February to introduce new legislative proposals that they'd like to run this year. The board is pursuing a number of legislative proposals we've been advised by the legislature to try to do it as part of our sunset bill this year rather than pursuing separate legislation. So we're taking the Assembly and Senate Business and Professions Committee's lead on that. They are currently reviewing our proposals to determine if it's something that they want in the sunset bill for the board, or if it's something that they want the board to pursue separately. It's looking like it's probably all going to go in the sunset bill, but we're awaiting final word on that. But the board has 4 different legislative proposals. One of them is basically a number of technical and non-substantive amendments that the board approved at its September and November meetings, and I've listed them in item by item in the memo. The second proposal, it's the statutory amendments to potentially allow the AMF-TRB national exam as the clinical exam for MFTs, which we discussed earlier today. The third piece is the 2 sunsetting statutory provisions that the board currently has in its law that sunset on January 1, 2026. It would be deleting the sunset date for supervision via video conferencing to allow it to be done indefinitely in all settings, and then extending the sunset date on the board's new temporary practice allowance. And then finally, we have a proposal for licensing requirements for LEPs, basically specifying LEP experience requirements in greater detail, clarifying experience requirements for in-state versus out-of-state school psychologists applying for the LEP license, and adding an age limit to the passing score on an LEP exam. So we're pursuing that. We should have some answers pretty soon about the sunset bill, and we'll report back at the February meeting.
Thank you, Roseanne. Okay, do we have any comments from our board, from our committee? No? Okay. Any comments from our participant in the audience?
Nope.
Any comments from our remote participants?
This is a moderator for members of the public on WebEx. If you would like to make a comment on this item, you can raise your hand or click that Q&A icon. And audio-only participants can raise their hand by pressing *3 on their device. All right, and it appears there are no requests for public comment.
All right, thank you, moderator. Next on the agenda is the update on board rulemaking proposals. Christy, would you provide us with the overview?
Yes, thank you. We have a number of regulation packages that we are working with that have been approved by the board. And the first one is the disciplinary guidelines. Those were noticed to the public for comment. The comment period ends on February 25th, so we'll be looking forward to that. I'm expecting we may get some comments that will need to be brought to the board in May. The telehealth regulations, the public comment period ended, and we did receive some comments for the board to review at the February 2025 meeting. The continuing education proposal will need to go back to the board in February for some minor modifications before we proceed with that proposal. The advertising regulation proposal has been submitted to the Department of Consumer Affairs for the production phase review, which is the one of the first steps in that review. And then the English as a second language, providing additional examination time. We are currently preparing those documents to begin that review process. And that's all I have.
Thank you, Christy. Any comments from our committee members? All right, any comments from our participant in the audience?
No, none here.
Any comments from our remote participants?
This is the moderator, and for members of the public on WebEx, if you would like to make a comment on this item, you can click the raise hand icon or the Q&A icon at the bottom right-hand corner of your WebEx screen. And audio-only participants can raise their hand by pressing *3 on their device. All right, and it appears there are no requests for public comment.
All right, thank you, moderator. Next on the agenda is public comment for items that are not on the agenda. As a reminder, the board may not discuss or take action on any matter raised during this public comment section, except to decide whether to place the matter on the agenda of a future meeting. Do any board members have comments for items that are not on the agenda? Abigail.
I'm in Southern California, and I wanted to just bring up that there was a lot of confusion I saw around therapists that were displaced and didn't have an office and didn't have access to their computer. They weren't sure like how to manage their caseloads and their clients without feeling like they were abandoning them, or if their clients were moved, right, to another state temporarily. I know that we do have some, we have some guidelines on the amount of days we can see them, but I think, just us talking about how to better inform therapists on how to manage disasters, I think would be helpful.
Thank you, Abigail. Would you like to put that on a future agenda?
Oh, yeah.
All right, so our process for that is we'll have Steve reach out and he will kind of help you figure out exactly what it is that we want to do to make it an agenda item for us. Okay. Perfect. Thank you so much. Kelly, anything from you?
Nothing from me. Thank you for letting me be here.
All right. Thanks for coming. Do we have any comments from our member in the audience?
It doesn't appear so. No.
Any oh, I think I skipped a section. Did I skip a section?
You might have gone to the not on the agenda first. So.
Right. So yes, I did. Luckily, Abigail's is a future agenda item, so that'll work for us. I apologize. We are going to be taking suggestions for future agenda items. Does anyone in the audience have an agenda item for a future board meeting?
No.
How about from our remote participants?
This is the moderator, and we are open for public comment on future agenda items. And it looks like we do have a request from Elise Springer. Elise, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hello, everyone. Elise Springer, marriage and family therapist, board chair, nonprofit California chapter of Postpartum Support International, requesting on behalf of the following 20 nonprofits, state, federal, and for-profit, that the board put 2581 as a future agenda item and consider including perinatal mental health as an education requirement. The following organizations include Postpartum Support International California chapter, Ensure the Uninsured Project, Maternal Mental Health Leadership Alliance, Maternal Mental Health Now, Return to Zero Hope, Sutter County Children and Families Commission, Los Angeles Best Babies Network, Postpartum Health Alliance of San Diego, MedExcel, Union Family Counseling, Reproductive Psychology Program, OB-GYN Department of Cedars-Sinai, Positive Change Counseling Center, Healing Home Counseling, nonprofit Be Mom Aware Sacramento, House of Healing Family Therapy, Maternal Health IOP at Sharp Mesa Vista, Love Dad, Children Now, Reproductive Mental Health Consultants, Women's Reproductive Mental Health Program at UCSD, Policy Center for Maternal Mental Health. The issues of critical importance, as perinatal mental health disorders have significant public health impacts throughout the state of California, particularly in light of recent events, both environmental and immigration related. It is crucial to emphasize that detrimental concerns can be alleviated and downstream effects can be prevented by timely diagnosis and appropriate treatment provided by adequately educated and licensed providers. Thank you.
All right, this is the moderator. Next we have Ben Caldwell, and Ben, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Caldwell, MFT. I don't know that this is necessarily an agenda item, but just if I could get an update from staff, and I apologize, there's background noise from construction here at the office. What is the status on the board's proposal to make changes to the 6-year rule? I know that's something that we as stakeholders get a lot of questions about. And I had expected to see it maybe in proposed legislation for this year, but I was curious just about where things stand and what next steps are needed there. Thank you.
We'll be discussing that at next week's Workforce Development Committee. The proposal should be on the website either now or posted very shortly.
Perfect.
With language.
Thank you, Roseanne.
Thank you, Ben.
All right, this is the moderator. Appears there are no further requests for public comment.
All right, thank you, moderator. And now back to the next agenda item. Any further public comments that are not on the agenda? Again, we cannot discuss or take action unless the decision is made to put it on a future agenda item. We've heard from our committee members. Are there any additional committee comments? No? All right. How about comments from our participant in the audience?
None here.
And what about from our remote participants?
This is the moderator. We are open for public comment for items not on the agenda. Members of the public on WebEx, you can either raise your hand or click the Q&A icon to indicate that you would like to make a public comment. All right, and this is the moderator. Appears there are no requests for public comment.
Excellent. Thank you, moderator. And our next item on the agenda is adjournment. Thank you all for participating today. As a reminder, our next board meeting will be on February 27th and 28th in Sacramento. We hope to see you then. I hope everyone enjoys their Friday and have a great weekend. Thank you so much.